What if I told you that there was a legal way to flip the power dynamic in a debt case by using 3 documents most people don't know exist? Now, in this video, I'm going to be showing you how to combine a affidavit of truth, a conditional acceptance, a notice of tender into one powerful package that forces your opponent to respond. Now, or even better, automatically lose standing. Now, I've studied commercial law, contract enforcement, consumer rights, and I'm here to show you how to use paperwork the system respects more than emotion. Now, before we dive into this, make sure you like and subscribe to the channel, okay? If you do that, that's a small free investment into the continuing of creating content specific for this. So make sure that you stay all the way to the end so that you can get any and all piece of this game, okay? A lot of times people don't have the attention span to not only watch the video, but also at the same time take notes so that they can have a full understanding and be able to do their own due diligence. Another thing, this is not legal advice, okay? And this is not financial advice. Do whatever you want with this information. I'm just putting out the game, so I'm not gatekeeping information that I study, okay? I study this on a consistent basis, so this is me giving you guys my findings, all right? And if you guys see my findings as a valuable way to empower yourself to start taking action, great. Okay, but other than that, I have nothing to do with that. My goal is also to keep you guys from being emotional when it comes to this process. A lot of people, when it comes to this process, are very emotional and they focus on the emotion behind the things instead of the strategy behind actually getting the work done. Okay, trust me. I've been in the same exact position before. As soon as I start listening to these things, as soon as I read Meet Your Straw Man, as soon as I read the UCC Connection, as soon as I read parts of the Redemption Manual, I'm not going to sit here and lie and say I read the entire Redemption Manual. A lot of people haven't. You know what I mean? But my goal is to take the emotion out. All right, and focus on actual concepts that you can utilize and use and start taking action, because you cannot get on the phone and start crying and complaining about truths that we know are to be true. Their goal is to obviously make you feel stupid, make you feel like you don't know what you're talking about, because they've been getting over on you on this entire time. And also at the same time, understand the system is rigged. So it's not our fault that we have to go through you have to do things a certain way. Some people will say, well, I shouldn't have to do this or I shouldn't have to do that. Well, that's just how the game is. You can't hate the game, just play the game. Okay? Now, let's dive straight into this. Okay? Some of the things that we're going to be talking about today is why the strategy works. Okay? We're going to be talking about the different types of documents. Okay, we're going to be talking about the aspect of how to package and send it. And, you know, as a matter of fact, just diving straight into it, we're going to be talking about the affidavit of truth. We're going to be talking about the conditional acceptance. We're going to be talking about a notice of tender and how to package this and send it properly so that they are not dishonoring you. Okay, and if they do dishonor you, how to be able to combat against that. All right, so this will be a very smooth video, so make sure that you guys are paying very close attention, staying all the way to the end. If you stay all the way to the end, then you will get a special treat. Okay, I may even show you the letter that I put together so that you guys can be able to get an understanding and be able to write your own letters. Now, let's dive straight into this. Why this 3-part strategy works. Okay, most people fight debt with fear or silence, but you're going to fight it with contracts, facts, and lawful offers. Okay, a lot of us don't understand that you can actually challenge them on the contract. You can have them provide the pertinent facts, and you can shift the burden of proof through lawful offers and saying, hey, look, man, I'll conditionally accept this, or I'm showing you these truths. Now you have to provide claims against them. And these are all lawful things that you can do. Okay, now, these three tools, when used together, can shift the burden of proof and expose whether the party has standing evidence or a valid claim. Okay, See, that's the whole aspect of this. Okay, our goal is to put them in a position to where they now they have to provide the proof. Okay, now they have to now they have to scramble for information and documents, because there is a requirement by the law that they must provide specific pieces of information. And if they do not provide specific pieces of information, then they lose that legal standing. Okay, so it's important for us to get comfortable with, number one, the affidavits that I'm about to talk about, but also number two, getting comfortable with writing back to debt collectors. Okay, it isn't always a solution to just go ahead and pay your debt. You can always write back to debt collector before you decide to pay. If it gets to the last moment and you just like, okay, this is something I want to just get off, by all means, do what you got to do so that you can be able to move forward in your life. But if you are in a situation where you're saying, okay, bet, well, I do want to challenge these people, I'm not about to let a collection agency take advantage of me. Or if I know that my car was charged off and I know that that money was settled, I'm not about to sit here and pay for a car that was charged off that they already made money off of. If you know these situations and you're like, hey, I'm not trying to be taken advantage of, by all means, do what you got to do. Okay. Now let's talk about the affidavit of truth. Okay. What is an affidavit of truth? The affidavit of truth is a sworn statement of facts. Okay, it lays out all the pertinent facts in regards to the contract, in regards to what has happened so far, in regards to who you are. When you think of affidavit of truth, just think of this is the truth, or all the truths that you know. Okay, and number one, if you give a statement of facts, typically they're going to rebut. So if it is unrebutted, given the fact that they will rebut, but if it is unrebutted, then these truths have standing in commerce. Okay, so understand that it's the same thing as a conditional acceptance, the same thing as you sending a presentment. If they do not respond, or if they do not rebut to it, then they agree to whatever the truths are. Okay, and if you put down the list of truths and they only respond to one piece of truth, then you're literally not denying the other truths. Okay, it lays out your position, saying pretty much no contract, no disclosure, no verified debt, and you can declare no lawful loan. You can declare no wet ink signature. You can declare that debt was paid by a third party, whether it was insurance or securitization, like we've talked about in our previous videos. And if they don't rebut every point, they agree by silence. So you cannot say, well, you agreed to something, but I never, number one, I asked you, I said, hey, you didn't provide a wet ink signature to show that I agreed. Okay, you did not provide a lawful loan. Okay, and I also said that your debt was paid by a third party. Okay, you can say I agreed to something, but did you respond to any of my other declarations? No, you didn't. Okay, a lot of times people will sit there and be upset that they respond back, literally like not responding to anything that you specifically said. And if they ignore you, then that's even better. You ignored me. You know what I mean? If you ignored me, then I'm in a better position than you are. Because what if I ignored you? What if you said I owed you $10,000 and I ignored you? Then that would stand true in commerce. Am I right or am I right? Okay. So it's important to understand that they don't rebut every point, and you have to know your points. You have to be very specific about your truths when you create your affidavit of truth, because a lot of times we'll just take a template and we don't even know what the heck we're putting out there as a truth. This is why I'm very keen on not just throwing out a template and telling people, oh, go buy this template, go buy that. I don't do that, because my whole important key is for someone to understand what it is that they are reading, understand what it is that they are looking at, so that when they do send it out there, they're not sending it blindly, hoping that me sending this will get me the result. So what happens is people will send this and say, well, I've spoken to people who say, I sent my affidavit of truth, this, that, and the third. I'm like, okay, well, what did you say in the affidavit of truth? What did you hope to happen? Well, they didn't discharge my debt. Well, okay, did you challenge them on the truths that you sent them? Did you respond back? Did they respond back? How did they respond? Oh, they just ignore me. Okay, well, then that stands true in commerce. And highlight that. Put them on notice that it does. Okay, since you guys didn't respond, everything that I just stated in my previous letter stand true. Or, well, I sent my affidavit of truth, and it's like almost like they didn't even respond to the affidavit of truth. They only respond to you not paying your debt. That's what they're trying to do. Okay. So boom, you send the affidavit of truth to lay out all the pertinent facts, whether it's about the loan, whether it's about the wet ink signature that you was not given, whether it was about the times you sent letters to them, whether it's about your standing in commerce, right? If I'm a living, breathing person, that's also a truth. If I'm a natural person, that's also a truth. So if you even went back and said, you have to respond to that as well. Because if I'm a natural breathing person, then I stand over you when it comes to commerce because you are a dead entity. So if I put that out there and I say, hey, look, I'm a living, breathing man or woman, okay? And you don't respond to that. Or as a matter of fact, if you say, no, you're not, like, come on, bro. Now you're going to have to prove that I'm not a natural, living, breathing person. You know what I mean? So that's the whole point. If I put out some truths, you're going to have to prove that it's not. You know what I'm saying? Now, then we dive into the aspect of conditional acceptance. Now we talked about this in my previous video. I'll go ahead and link that as well. We're at the 10-minute mark. I'm sure when I cut this down, it'll probably be like 8 or 9 minutes. But I'll go ahead and put that up here so that you guys can be able to access it. Okay. Now, conditional acceptance. You know what I mean? When it comes to conditional acceptance, it is powerful because it doesn't deny anything. It agrees if they can prove their claims. Okay, so it forces them to produce information in regards to the contract that is true or not true. If you say something is a certain way, then I need you to produce that. Okay, and if you can produce that, then I will pay you. See, now it's not even a conversation of saying that I won't pay you, right? So they can't say that I didn't perform on a contract. It's an aspect of saying, hey, look, well, boom, if you could produce the original contract, if you could produce the proof of lawful consideration, if you can produce that chain of title, if you can produce the accounting, and I'm asking you for 4 items, then I will accept or agree to whatever it is that you're telling me to do. And they do the same thing to you. They can do the same thing to you. But if you do this, this will keep you in honor under UCC 1-308, which is the all rights reserved code. Okay. It also keeps you in honor under UCC 3-501, which talks about presentments, I believe. Let's pull it up. UCC 3-501. Presentment means demand made by or on behalf of a person entitled to enforce an instrument to pay an instrument made to a drawee party obliged to pay the instrument, or in case of a note, accepted draft payable at a bank to the bank to accept a draft made to the drawee. So let's dive straight in. Okay, when you send a presentment upon demand of a person whom the presentment is made, the person making the presentment must exhibit the instrument, give reasonable identification. If the presentment is made on behalf of another person, reasonable evidence of authority to do so. Sign a receipt on the instrument for any payment made, or surrender the instrument if full payment is made. Okay, and it says without dishonoring the instrument. Okay, the person to whom the presentment is made return the instrument for lack of necessary endorsement, refusal of payment or acceptance for failure of the presentment to comply to the terms of the instrument, an agreement of the parties or other applicable law or rule. So long story short, once you send this presentment, they now have to, this is you moving in honor. Okay. Long story short, when you send a presentment to a company, they are now under contract to follow directions and not dishonor you. Okay? A presentment is you moving in honor. Okay? And if it's not, then you're going to have to prove it to me. Okay? So then we dive into the aspect of exactly what it says. I accept your claim upon proof of X, Y, and Z. If you can prove it, then I will pay it. And this doesn't put you in a position where you're saying you're not going to pay it. So you can't go on court and say, well, he just doesn't want to pay it. No, he said, if you can prove X, Y, and Z, then he will pay it. Have you proved it? Where is your proof? No. So I love the conditional acceptance process, and paired with the affidavit of truth becomes an excellent tool. Okay. Then on top of that, this is when you want to pair that notice of tender. Okay, so if you were to do a remittance coupon, if you were to submit a 1099, right? If you were to create a promissory note, okay, you offer, and this is essentially you offering a lawful payment or discharge. Let's just say if they do produce this information, this can include that promissory note, that coupon remittance. This could include that bonded instrument. This proves you made a good faith effort to settle the account. Okay? Now, let's just look at the definition of tender. When you look at the definition of tender, tender is to unconditionally offer money or performance to meet an obligation. So it doesn't say up here that tender is money. Okay? It's a verb. You know what I mean? To unconditionally offer money or performance to meet an obligation. That can mean anything. If I just told you that a presentment is a performance, then technically that is a tender. If a promissory note is a unconditional offer of money, then it can perform to meet an obligation. Okay? When there you see that or, that means either or. Okay? So essentially, if you send this and they try to say that it's not legal tender, they'll have to prove that it's not an unconditional offer of money or performance to meet an obligation. That's why I love this. That's why I love taking a look at the law and reading the law, because in certain situations, they cannot prove certain things. Okay? So, and because all you have to do is pull it up. They're going to have to go against the Constitution. Now, if they reject it, it is equal to a dishonor. Okay? So, this is why we send a notice of dishonor. Okay? When you send a lawful tender or a good faith effort to settle an account, it says here that the protest must identify the instrument and certify either that the presentment has been made, or if not made, the reason why it was not made, and the instrument has been dishonored by non-acceptance or non-payment. The protest may certify that notice of dishonor has been given to some or all parties. So essentially, when there is evidence of dishonor, then that is something that they must answer to and provide reasons why they dishonored. Okay? Now, here's the other aspect when we look at the tender of payment. UCC 3-603 talks about the tender of payment. The obligation to pay instrument is made to a person entitled to enforce the instrument, and the effect of the tender is governed by principles of law applicable to the tender of payment under a simple contract. So let's dive into what is the main key of the tender of payment. Okay? If a tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, then there is discharge to the extent of the amount of the tender of the obligation of the endorser or accommodating party having the right of recourse with respect to the obligation in which the tender relates. So if you put out there that, hey, look, man, I'll conditionally accept this offer if you can prove X, Y, and Z, boom, let's just say they prove it. You then send your notice, your tender with your notice of tender. Okay, if I'm going to do a promissory note, then I'm going to put them on notice that this is my lawful tender that I'm using to settle the account. And I'm putting you guys on notice that I am moving in good faith to settle the account. They reject it. There is a dishonor because you're literally dishonoring my tender of payment. And then we dive into you guys refusing or saying that my tender is not something I can lawfully use. Then there's discharge, okay, to the amount of the tender. So if my promissory note says that, hey, look, man, I promise to pay 10 grand in order to settle this debt. Okay, and this is what a promissory note, on the very simplest term, is essentially doing. A promissory note is an IOU, just like that Federal Reserve note. If you want to look at the Federal Reserve Act Section 16 and understand exactly how the banking system works and the fact that they just literally loan IOU dollars and give it to us, or better yet, they do accounting entries in our account, which is the definition of an unpaid balance, you'll understand that money isn't exactly what it seems. Okay, it's all a promise. So if you wrote an actual promise to pay, that is the same, if not more value than an actual dollar. Okay, because this gives them the ability to take it and then multiply that money even more. Okay, so long story short, here's my lawful tender of payment. If you refuse it, then the obligation is discharged. And if you put that all in one letter, you put this all together, there's no way that they're going to sit there and just not just openly just refuse it. And they will, and they may. You know, if they do, then you already said that it's discharge. So yes, go ahead and take me to court and try to say that I didn't perform my contract, and I'm going to show all my evidence and all my communication between all of you guys and everything that I laid out, and you guys are going to have to prove that that wasn't lawful tender. Okay? Now, here's how to package it and make sure to send it properly. Number one, you want to include all docs in one notarized mailing. Okay? Number two, you want to title it Commercial Affidavit of Truth and Tender Offer with Conditional Acceptance. You want to send it via certified mail with a return receipt. Okay? If you send it with a negotiable instrument registered, this is also a good way to send a notice of tender, but also at the same time a legal tender or a negotiable instrument. If you send it registered, then it gets insured. But even if you don't do that, you can send it certified, but make sure you send it to all parties involved, because either way, they're still going to have to answer to whatever you send them. Okay? Send it certified or registered so that you can get that return receipt. If they fail to respond point for point, you send a notice of fault and then a notice of dishonor. Okay? You got to put it on notice. Hey, you guys didn't respond point for point. Yes, you say I agreed to X, Y, and Z, or you can tell me that this is a lawful tender, but I broke down why this is. Okay, so now you're going to have to respond point for point. And if you didn't, then it's a notice of fault. Forget everything that you're trying to claim. If you don't answer what I conditionally asked you, then you are at fault. Okay, and if you continue, then you will have dishonored me. So if that is the case, this is evidence that they can use, that you can use if they decide to take legal action later. Now, understanding that when you combine truth, acceptance, and lawful settlement into one package, you are no longer begging for forgiveness. You're demanding evidence, standing in honor, and forcing the system to follow the rules, and that's the real power. Now, let me show you this. I'll show you guys personally what you should be asking in regards to an affidavit of truth, what a conditional acceptance looks like, and if you were to put all of this together, how they should be interpreting this. Now, I'm going to be going through this very quickly, and obviously do your due diligence, okay? This is also included in my Complete That guide, so if you want it, go ahead and grab it. If you're able to sit through this video, write every single thing down, by all means, go ahead and do it. Now, obviously, if you go ahead and title it properly, you add your trust name, address, so on and so forth. You put the creditor, collection agency, servicer name. You title it Affidavit of Truth, Conditional Acceptance, and Notice of Tender regarding alleged account. Reference, you put in that reference number. In your Affidavit of Truth, you're putting, boom, my name is blank. I, Nicholas, a living man, woman, declare the following to be true, correct, incomplete, to the best of my knowledge. Number one, I have no verified knowledge of a lawful contract, agreement, or obligation between myself and your agency or any alleged creditor. I have never received full disclosure, consideration, or a wet ink signature agreement proving a meeting of the minds. Okay? Number three, I dispute the alleged debt in its entirety and assert that it may have been satisfied, bonded, discharged, securitized, or otherwise settled. Number four, I am unaware of any lawful claim your office has that supersedes my rights under contract, commerce, and Constitution. This affidavit stands as truth unless rebutted point for point within 10 days of the receipt. So then we dive into conditional acceptance. I hereby conditionally accept your presentment and claims upon the receipt of the following: a certified copy of the original signed agreement bearing my wet ink signature, proof of lawful consideration exchanged at the inception of the agreement, a full chain of assignment from the original creditor to your office, a full accounting and ledger under UCC 9-210 showing all debits, credits, discharge, and insurance payouts, proof that no third party has satisfied or offset this obligation, and 6, valid proof that your office is the holder in due course under UCC 3-301. Absent of full compliance, your claims will be deemed unsubstantiated and no legal or moral obligation shall exist. Now, enclosed is a lawful tender of payment in the form of private remittance, coupon instrument offered in good faith in accordance to UCC 3-603 and the applicable tender law. This tender constitutes a bona fide effort to discharge the alleged obligation. Any rejection or refusal to process this lawful offer constitutes dishonor under UCC 3-505. Okay, failure to rebut this package within 10 days will result in your default in agreement to all terms expressed herein. Okay, all rights reserved without prejudice. UCC 1-308, reservation rights. If you send a knockout letter like this, okay, it is no way, and I'm going to have to just flip off of that. If you want that, go ahead and grab the Complete That guide. Go ahead and go back and reread it. Write every single thing down. Look, I don't even care. You guys don't even have to go on the Complete That guide to get this. You can go reread it. You dig me? And write everything down. But if you want my template, go grab the Complete That guide. It's only $47. Okay. Now, understanding that you can put this all together in one letter. A lot of times we think we need to do all of this, package this, that, and the third. But if you have the simplest understanding of how to put together, what exactly you should be asking them for, and you have a simple understanding of, affidavit of truth, conditional acceptance, a notice of tender, you can put this all together in one letter and you can challenge them directly. And when you put all of these things here, you give them specific instructions. You lay out exactly what it means if they dishonor you or they ignore you. So if you go in court and you show this information and they are trying to rebut against this now in court, and you already said within 10 days, if you don't respond, then you dishonored and you essentially accepted everything, and you don't respond point for point. Not that you just respond. You have to respond point for point. If you don't respond point for point, then you are deeming everything that is on here as true. You're deeming that you cannot prove my claims to not be true. Okay, you cannot prove your lawful consideration. Okay, you cannot show that you are the holder in due course. Then what am I, by law, which I don't have to do? If you cannot prove these things, you cannot do nothing about it. Okay? And that's the beauty. Because if you challenge them, if they challenge you on these things, they would expect you to make sure you go point for point. Okay? And yes, by all means. But send this to all parties involved. Don't just send this to the customer service. Customer service may not know what to do with this. Make sure you send it to customer service. Make sure you send it to payment processor. Make sure you send this to the legal department if you got their number. Make sure you send it to their legal counsel. Make sure you send it to every party involved. Make sure you send it to the headquarters. Because a lot of times what we'll do is we'll just send it to one party, and then they'll send us a letter back of some pre-automated response saying that, oh, you cannot do this or this, that, and the third. But hey, even if you sent it to the wrong person, there's a thing called a court of satisfaction where they're supposed to make sure to deliver it to the right person. Okay? If they don't deliver it to the right person, then whose fault is that? But still, make sure you do your part and you're sending any and everything to all parties involved. Now, we've got all the way to the end. Okay? If you stayed all the way to the end, you're a real one. Make sure to comment that word discharge, because I will consistently drop more bangers knowing that you got to the end. And I'll keep giving you guys treats and tidbits so that you guys can be well away on your journey. Again, this is not legal advice. I'm putting out the information that is available to any and everybody that watches these videos. This is probably a banger video. Okay? So, if you want that 3-part affidavit, go ahead and grab the Complete That guide. It's only $47, okay? If you want to work with me one-on-one, okay, and tap into my mentorship where I focus on helping you build your credit, helping you get funding, and helping you start a business, tap in my one-on-one mentorship. If anybody taps into my one-on-one mentorship, it doesn't take out the fact that you will get all of the game that I know about this. Now, I won't do no work for you, but I will make sure that you know and understand any and all of these truths that I'm talking about. Okay? So yes, my one-on-one mentorship is geared towards credit, funding, and helping you develop a business. But obviously, if you tapped in with me and you're in my pocket, then you're going to be able to get all of this. Now, this is for people who want to change their lives. Okay? Not only financially, but want to break those generational curses, that want to help their family out in a big way. Those people that want to actually become something and leave a legacy. tap into that one-on-one mentorship. This is not for somebody who's just trying to do something small with their life. This is for somebody that's trying to do something big. This is somebody who wants to actually, create something for themselves and leave a legacy. If you're not trying to do that, do not apply to my one-on-one mentorship, because that conversation is going to be very deep. And if it's very surface level, then you're probably not going to fit for what we have going on. Okay. But if that's something that you want to do, or you want to be able to change your circumstances, change your life, and you want to be able to connect with somebody who is, number one, doing it, but also at the same time willing to give you the guidance and the focus so that you can be able to move forward, tap in with my one-on-one mentorship. Okay. My time is valuable, so I only give my one-on-one time to certain people. Okay. Now, number 3, follow me on Instagram for daily consumer law and credit game. Or if you want to be able to get tapped into every time I drop a new YouTube video, if you want to be able to be tapped in every time I drop some more game, whether it's a video, motivation, mindset, tap in with your boy at biz.nick on Instagram. Have you ever tried sending an affidavit or offer to settle and got ignored? Tell me what happened in the comment section. Make sure to like, subscribe, turn on the post notifications, because this is how we fight with facts and not fear. Fight with facts without emotion. You dig me? If you got all the way to the end, make sure to comment the word discharge, and I'll see you in the next one.